Over to you, Akshaya.
Thank you, Urvashi. Thanks to Dr. Nitishika for inviting me. I'm very happy to be talking about this. I'm going to talk, as Urvashi said, about the insolvency measures in response to COVID-19 in New Zealand, but I'm also kind of going to highlight a few things as I go in terms of what I think will be good talking points for India. And before I get started with the reform package in New Zealand, just to kind of look at what look at it against the grain of what other countries have been doing in terms of responding to COVID-19, you essentially see two things, right? One is providing a sort of safe harbor for directors from liability from those provisions that require directors to put the company into insolvency proceedings when the company is approaching financial troubles or in the shadow of insolvency or whatever terminology each jurisdiction uses. And the second common thing we've seen across countries is increasing the threshold amount of debt, that default on the debt that's required for a creditor to be able to compulsorily put the company into an insolvency proceeding. And I've specifically spoken about these two measures being used across countries because it's interesting to see that New Zealand has introduced the safe harbor approach, but not really increased the threshold for threshold requirement that creditors threshold for creditors to be able to compulsorily take the company into insolvency. On the side of it, that's for Pulkit to talk about, but I've just said in India now, after the ordinance, we've seen that there is a safe harbor for directors, perhaps a little too safe for directors at the moment. And much prior to the ordinance, we saw that there was increase in the threshold for creditors to be able to compulsorily that is, file a statutory demand and take the company into insolvency proceedings. And then I've put in a third issue, that is the business debt hibernation, which is uniquely introduced in New Zealand. And I'll come back to why New Zealand didn't introduce this second item. But let's carry on into I think I've jumped too slow. Into the safe harbor procedure introduced in New Zealand. So this is quite similar to what's introduced in other countries, but I'll kind of talk about why I think it's interesting just in a minute. But essentially, with the two sections in New Zealand dealing with obligations of directors in the context of insolvency or twilight zone close to insolvency are sections 135 and 136, which in most cases get kind of used together, but the one is called reckless trading, the other is duty not to take on any obligations unless the company directors believe that there are reasonable grounds to think that the company can actually perform on those obligations. With reckless trading, the wording, and I've highlighted the main phrase, that operative phrase, that is, if the directors are operating the business in such a manner as to create a substantial risk of serious loss to the company's creditors, then they would be liable. So New Zealand has provided temporary relief from these two sections, but certain conditions need to be met. And these conditions are kind of, you'll see them overlap again when I talk about business debt hibernation. So it's kind of interesting to see the three conditions. And again, I'm going to start talking about good faith requirement on the part of directors here, and you'll see that recurring throughout the New Zealand reforms as a theme. But essentially, you need three conditions for the safe harbor protections to kick in. The first is that the director should have made a good faith assessment that the company is facing or likely to face solvency issues in the next 6 months. And again, I've highlighted this because these solvency issues need to be as a result of the impact of the pandemic for the safe harbor to be available. And the second is for the company to be able to pay its debts as and when they've fell due as of 31st December 2019, again to ensure that the company didn't have already pre-existing solvency problems. And the third is for the directors to have made a good faith assessment that it is more likely than not that the company will be able to pay its debts as they fall due on or after 30th September 2021. So you see the safe harbor has quite a big spread from 31st December 2019 to 30th September 2021. But this good faith assessment here is for the directors to decide that once conditions are like trading conditions are likely to improve, then their solvency issues would improve as well. So essentially, a lot is riding on directors acting in good faith and making these assessments about future cash flow of the company. And let's hold on to these thoughts because like I said, that repeats in the business debt hibernation regime that I'm going to talk about. So along with this safe harbor for directors against liability from these insolvent trading provisions, New Zealand has introduced something, the business debt hibernation as a regime over and above the existing insolvency uh, procedures in the country. And it's quite simple, as the term suggests. It's simply to allow companies to hibernate their debts a period of 6 to 7 months or more. And this is, you can think of it as a kind of creditor workout as well, because it has creditors needing to be involved and agreeing to it. So let's go step by step. The first step, like I've just said, is almost a repeat of the safe harbor, the requirements to get the safe harbor protection. So it's a bunch of good faith assessments we're looking for here. First, you want to ensure that the directors make a statement that the company was solvent as of 31st December 2019. Second, you want at least 80% of the directors of the company to agree that the company should enter the business debt hibernation regime, and they need to make a declaration that the solvency or liquidity issues of the company stemmed from COVID-19, and that they believe that the company is likely to pay its debts as of 30th September 2021 based on trading conditions improving, etc. And third, they need to be acting in good faith. So once the directors have made these assessments, then at step 2, they need to notify the registrar of companies of their intention to register to enter the business debt hibernation regime. They also notify all the creditors, and with this notification of the registrar and the creditors, you have an automatic moratorium for 1 month on all pre-existing debts kicking in at that point when the notice is filed. So during this 1 month moratorium, management of the company, directors are expected to meet with creditors and decide on whether this business debt hibernation regime should be entered into for a longer period of time. So essentially that's step 3. In step 3, we expect creditors to have met with directors, and if they think that if they're confident of the company's conditions improving over a period of time, then they eventually take a vote, and if you have at least a majority, 50%, a majority in both number and value of the creditors agreeing to enter this business debt hibernation regime, then you have another 6-month moratorium kicking in. So essentially, this gives breathing room for the companies. And this moratorium is binding on all creditors, but not on employees. And that is the essential features of the business debt hibernation regime. But as you would expect, you also have some suspension of the voidable trading provisions. So with the voidable transactions regime, there is an exemption for any payments, dispositions of property, etc., that the company makes to third parties. after the company enters the business debt hibernation regime. But there are exceptions here as well. If you see what I've highlighted, it says this exemption is again only available for transactions entered into in good faith by both parties, and also it's not available for related party transactions. So there's that as well. And so to give effect to that, you have two other sections having been amended accordingly. And so, as I said earlier, you don't the threshold requirement for a creditor to take the company into an insolvency regime, insolvency procedure hasn't really increased. The amount in New Zealand is actually much lower than in Australia. It's 1,000 New Zealand dollars. So the moment you have 1,000 New Zealand dollars due and payable, a creditor can very well take the company into one of the other insolvency procedures rather than a business debt hibernation. So why exactly has New Zealand not done anything about this? I would think it's more because with the business debt hibernation, they're looking for a cooperative solution where creditors that believe that this company is viable and is likely to start trading soon and is likely to pay its debts would voluntarily enter into this rather than just disallowing creditors and creating some kind of a exemption for debtors to continue defaulting up to a higher amount. And kind of flowing from that, I just want to make a final point about what incentives there are to cooperate for directors on the one hand and creditors on the other hand. And I think this is where in the title I mentioned, I'm calling this a debtor in possession model. So yeah, through the business debt hibernation regime, the debtor company's management remains in control. So that would be one incentive for directors to prefer this regime over the others. And for creditors, only 50% need to vote. So probably if you have the confidence of 50% of the creditors, it's not a problem. Just wanted to refer to Oxford academic suggestion, unrelated to New Zealand, but mostly in countries where you would need more than a 50% vote. They've suggested that you need to impose creditor cooperation duties just for this post-COVID time. And that would ensure at a minimum that creditors would need to negotiate in good faith. And this kind of gives the counterbalance to what I've been saying so far about the entire recurring theme of the New Zealand exemptions for directors being that the directors act in good faith. So perhaps that kind of a duty on creditors is not so bad. So maybe I'll stop here and let Pulkit respond and we can come back to discuss later.
Well, thank you ever so much, Akshaya. That was quite succinct, and I think you've hit a number of elements that I thought that I would bring up. And before I start, I just want to thank Neeti and Urvashi for organizing this and for giving me an opportunity to have a chat with you today. So I think before I get into the elements, I think it's very important to admit, at least for me, at least in my view, it's very important to admit as to what is the right mix of legal, financial, and regulatory measures to deal with the situation at present is anybody's guess. I don't think that today we can, we've got the 2020 vision in order to say that this is the right way forward. So I think, the classical approach to the government with economic legislation may not be the wrong thing, i.e., it's got to be experimental. We've got to keep changing our approach as and when we discover new things that may be relevant or some things that are not working so well. And so leading on from there, I think it's also important to note, what the rest of the world has done. Besides the obvious, director liability issues and qualifying threshold issues, and there are at least three that sort of catch my attention as such. And the first of that is special rules for small companies. I think that's of paramount importance. You've got to make it simpler for small companies. The second one that's got my attention are measures for the duration of insolvency proceedings. So to say, a fast track process of some sort, or a pre-insolvency process of some sort. And the third one, and I think this is of paramount importance just as much, is facilitation of rescue financing. And without getting into all of that just as yet, I'm just going to try and go through a few things over the next 5 minutes. So let's be clear. I think it's important to be clear that there is a real risk of an overkill. We may not know where to stop. We may not know what the right balance is. And such an overkill may be deliberate, it may be inadvertent. But the objective in whatever we bring about, or whatever changes we bring about to what we've already got, have to be, one, to support financially distressed businesses, and two, prevent unnecessary winding up. The key word here is unnecessary. And I say that specifically in the Indian context, where we brought in an omnibus legislation that was celebrated in 2016, and in just as much an omnibus way, we've put the whole thing into hibernation for a period of 6 months to 1 year without thinking about whether or not it is necessary or unnecessary. Whether or not for a specific company it is necessary or not unnecessary is what I meant to say. Now, coming to the essential features, in my view, the two essential features. The first of which is it is very important that a moratorium, which is one of the two essential features that I want to talk about, is appropriate and it is effective. That is, it also bars legal action and prevents termination of contracts. And in my view, the suspension of IBC is only half the story. It cannot by any measure be the complete thing that is hibernated by, that's put into hibernation by way of a moratorium. This is something that India does not have. And the second thing that's very important in my view for India to now bring out is a measure to facilitate workouts. That is, creditors have to be disincentivized to prefer, they have to be incentivized. At present, they are not incentivized to prefer a workout over a recovery or an enforcement proceeding. And in fact, the RBI circular on the COVID-19 issue has which basically puts a standstill as to NPA classification, has a very unfortunate reaction as well, which is it also disincentivizes the debtor from making any reasonable efforts to try and restructure or to come up with a restructuring scheme in accordance with the erstwhile 9 June circular. Because the unhappy coincidence is that there's a standstill as to the timelines of the 9 June circular as well. Now, I'd just like to sort of conclude by saying that, moreover, we have nothing at present that facilitates workouts with non-scheduled lenders, because the 9 June circular only talks about scheduled lenders. So we've got nothing that talks about workouts for non-scheduled lenders and operational creditors, besides a scheme of arrangement, which, of course, in this situation may not be fit for purpose, given that it's slow as it is. I don't think we need to get into why it is slow. Suffice to say, there are various procedures involved, various meetings, at least 2 motions before a court, and so on and so forth. And it just isn't fast enough. And for that reason, I reiterate this point, we have nothing at present that facilitates a workout between non-scheduled lenders and operational creditors along with scheduled lenders. And I think that may be something that we need to work on. So thank you very much for giving me the first 10 minutes. And I think next thing we've got is a few questions that I have for Akshaya. And I'd really like to have your opinion on what we can do to address the issues that I've raised in the last 5 to 7 minutes. So the first thing really is, how do we address this issue of lack of motivation? I think that's the first gap, at least that I've raised. There's a lack of motivation. How do we address this issue of lack of motivation? So in answering this, could you just think about maybe what are the essential elements or ideal features of an appropriate and effective moratorium?
So yeah, I think thanks first of all, Pulkit. There was an interesting summary of the difficult situation we've put ourselves in India right now. In terms of motivation, again, I'll think of both sides, right? What are the incentives for companies on the one hand and incentives for creditors on the one hand? In normal times, you'd think the incentive for companies in under the IBC in India would be that, okay, the creditor is going to take us to compulsorily take us to the insolvency procedure again under the IBC. And as I've kind of spoken in a previous paper I'd written about it, that, and I think we know about Jet Airways, right? So there are defaults. Everyone knows there a company hasn't paid its debts, but somehow creditors aren't really taking that company into the insolvency resolution process. So there are those sort of realities as well. So you'd say that that's ideally the incentive, that creditor is going to take us to court under the insolvency procedure. So let us try and think about an informal workout. But if that's not happening, then the incentive to actually negotiate and take offers, even if they're coming, is kind of very thin. But and now that's totally gone with the IBC filings under suspension. So I kind of really found the suggestion by in the end that I discussed from the Oxford academics, saying that creditors should have a duty to negotiate in good faith, to be especially useful in India now that we don't have the option of taking the company into insolvency proceedings at all. And then, of course, with the debt, since they're sitting pretty at the moment, no, there is a safe harbor, a very safe harbor, as I said, because there is no way anything they do right now can be challenged later if you go by what the ordinance says. So yeah, it is hard to ensure that the company is also motivated to engage in these workouts. And so I think we need to currently, and I know there's been some talk from the government about introducing pre-packs, but of course everyone should be motivated, as you say, to get into these sort of negotiations. So unless there's something more coming from the government, I don't see how you'll have the right incentives for debtor companies and creditors at the moment to restructure at all. Just an interesting thing I saw this morning was somebody, I think the State Bank of India, taking one of the directors of Reliance personally filing personal insolvency proceedings against him, saying that he had given a personal guarantee on his debts, and now the ordinance doesn't bar initiation of insolvency proceedings against individuals. So you can, I guess, see such creative workarounds. I don't know. It's interesting to see what happens. Have I answered everything?
Yeah, that's right. No, that's absolutely right. It's quite interesting. It is quite interesting that it's only in respect of corporates that that there is that the IBC has been put into hibernation, shall we say, but not in respect of individuals. But a very important point there is that in respect of individuals as well in India, insofar as the notification of the IBC is concerned, it has only been activated in respect of those personal guarantors where the corporate debtor has already been put into insolvency. So whereas it helps, it is still helpful in respect to those companies that have already been put into IBC. it is not helpful in respect of new defaults.
Right. Okay. Yeah, and I think these companies were already undergoing proceedings under the. Okay. Yeah,
That's right.
so I see kind of we've tied ourselves into a knot. If the government doesn't do any more to put in incentives, I don't see a solution here.
Yes. Yeah. And the counterbalance there. I mean, so empowering the debtors so that they're not pushed into insolvency is one. Um, but do you think that there is a need for a rudimentary moratorium as such in respect of enforcement proceedings or civil suits for recovery, or do you think that should be left to take its own course, so to say?
I think before this goes to Parliament and something more comes from Parliament at the moment, while we have this ordinance in place and we're expecting companies and creditors to simply come up with workouts with no moratorium in place, the real danger is to see some creditors actually enforcing debts by themselves or agreements by them in court, through civil proceedings, and kind of undoing everything we've done with the IBC, saying that okay, viable companies should be saved, as you said in your talk, that we need to ensure that viable companies don't get wound up unnecessarily. So if that's the interest of the government, and that should be the interest of the government at the moment, then we have to have some kind of moratorium in place. But I like the New Zealand model where the moratorium comes in place only when you have at least 50% of the creditors agreeing because they think there is some viability there.
Yeah, yeah. And unfortunately, as I sort of noted earlier, the June circular, which gives you that 30-day period to assess whether or not the company should be restructured or whether enforcement measures should be taken, that itself has been put into a standstill. So that doesn't come to a rescue. And of course, that only deals with scheduled lenders. It doesn't deal with
Right.
unscheduled lenders and operational creditors. Um, so I think this leads us nicely into the question: what are the changes that you think that you would suggest that once the ordinance makes its way to the Parliament? What are the things that the Parliament should reconsider, so to say?
Oh, so I was not happy with the idea of a blanket suspension of insolvency proceedings completely. So already India raised those thresholds in terms of creditors not being able to take debtors to court unless the default is big enough. But we have to allow for companies that want to themselves go into insolvency proceedings to get that moratorium. And till then, what I was saying about having a temporary moratorium that creditors agree to, etc., is a nice temporary measure or a kind of alternative. But I think the main insolvency proceedings under the IBC should be made available. Hopefully, when it goes to Parliament, this blanket suspension will go away overall. But even just keeping that aside, the thing relating to voidable transactions or fraudulent intent, what is the title of the section, that the section 66 that has been
Section 66.
amended?
Yeah,
Sorry.
Section 66.
Yeah, so that amendment is also problematic because it's talking about directors, that section being nullified, or nobody being able to bring any action against directors for defaults under that section, which means that, and this is something I stressed on throughout my presentation on New Zealand, saying the threshold requirement for business debt hibernation or safe harbor is the existence of directors acting in good faith. While section 66 is only applicable, at least the first subsection is applicable for fraudulent transactions or directors acting with malintent. And if that's suspended, it means that anything goes at the moment, which is a really sad state of affairs. So at least that needs to change immediately. And then even with the suspension of IBC, I'm not clear about the rationale. The ordinance itself says that the rationale is that there aren't enough people ready to put up plans and finance. And you mentioned this about availability of finance and buyers, and I take that. But I think there is an added issue of the courts being overloaded. So there is, of course, that problem. So having alternatives like something akin to the business debt hibernation regime being an option would allow the courts to kind of have a easier job if many companies and creditors choose those alternatives. So I like to see a more flexible system with a number of options. So the court is not overloaded, but it's not really telling companies exactly what to do, but allowing them to choose.
Yeah, I think what you suggested is at least three things that I've understood. One, to deal with Section 66. Of course, we've got two subsections within that section. One that deals with fraudulent trading, and the second that deals with wrongful trading. And although at present the whole of Section 66 stands suspended, it makes more sense to only suspend the wrongful trading subsection and not the fraudulent trading subsection. Because there's really no rationale for suspending the fraudulent trading subsection. I think the second thing that you said, and I completely agree with that. The second thing you said, which is of course something that can be discussed a bit further, is the blunt force with which Section 10A suspends sections 8, 9, and 10. 7, 8, and 9 and 10. For a period of 6 months for all defaults that have occurred from the 25th of March onwards. Now, the first thing to note about this is that there's an explanation at the bottom which says that that these defaults could never become a subject matter of an insolvency petition. That means that not for the next 6 months, but also forever and ever. So any default that takes place during this time, it would never be a subject matter, even once Section 10A has run its course, which is very interesting. Do you think that that makes any sense as such, or do you think that needs to be reconsidered?
Yeah, that needs to be reconsidered, but I think it was a case of bad drafting. In terms of the way I read it is they were trying to say that these debts are at the moment suspended, but as long as it's paid off after these defaults won't be actioned right now, but if it's paid off after the suspension is at an end and things are back to normal, then those debts need to be paid. Otherwise, I think it makes no sense. Maybe I'm just reading it too generously. But as you said, it means that these defaults can be forever defaults. They'd never have to pay those debts, which kind of makes no sense. So I hoped or generously read that it was just suspended for now.
Yeah. No, there's an explanation as well. I see that there's a serious potential for mischief there, because a company who is not otherwise insolvent, who has the money to pay the debt, would rather default now because that company knows that its creditors will never be able to do anything about it, aside from file a civil suit. And of course, we are a litigious, we are a very litigious culture because it's very cheap to go to court over here. And so I see that there's a serious potential for mischief. Maybe the correct approach, in my view, would have been to suspend the remedy, not the right. I think that's how Mr. Shroff put it in something I read that he had written. I completely agree with him.
And that would be kind of similar to what New Zealand has done in terms of just hibernating the debts for now, but it all needs to get paid later. So yeah, you're right. And we're such a litigious culture that I think we'll spend a lot of time just litigating the meaning of this ordinance because it's open to such questions, right?
Well, the other thing that I was thinking before I saw the ordinance, and I thought that it made a lot of sense, is what the UK have done. They have given a discretion to their judges to say that if
Mm.
this default is specific, if this default, in your view, I mean, they've given them discretion to decide that this default relates to COVID, is because of COVID and not because of any other reason. Um, and they then have the discretion to dismiss an insolvency petition with that observation. And that would have made more sense. But do you think that
Yeah,
that's
because
something that would work for India, or again, we've got the litigious culture and we'll all file petitions and see how it goes?
yeah, there's two things there. I want there to be some sort of a criteria within the ordinance or within any law we come up with to say that this has to be COVID-related debts to be able to take the benefits of these reforms or temporary measures. And something like New Zealand, where directors are giving a statutory statement saying we genuinely state that this is relating to COVID, and then letting the judge also in our case tribunals also have a decision making power as a second step is good, but I'd kind of worry about giving the NCLTs too much discretion, because at this time the last thing you want is for us to reach a situation where most tribunals are trying to give the benefit of doubt to companies because they're in trouble. They want to save employees' jobs. We've gone down that road before in the BIFR.
Yeah,
So hopefully we can have clearer laws.
yeah, yeah. No, that's right. That's right. So maybe this is the right thing to do for India at least.
Perhaps.
Yeah. Um, the next thing that's very important, that's very interesting, is of course we've thought about the creditor's right to petition. What about the debtor's right to petition? Why? What is the motivation? What is the possible motivation behind suspending that? I mean, why Section 10?
That completely beats me actually. Suspending, I see no, I don't see the rationale at all to say that debtors should not be allowed to start insolvency proceedings, because especially like I said earlier also, I've not in Jetway Airways, in big cases where creditors aren't actually going and starting insolvency proceedings even though there are those defaults, we didn't see debtors running to court because there is that disincentive, right? They lose control. Control goes to an insolvency professional. So when there isn't that much of a rush to start proceedings just to get the moratorium, I don't know. It totally beats me why that was suspended.
Yeah,
The only thing I can think of is possibly because the courts are not functioning as much as before with the going online and things like that. So just to give the courts relief, that's my reading, although the ordinance doesn't say anything about that.
right. Because I mean, one would be forgiven for thinking perhaps that just suspending Section 66 subsection 2 would have been sufficient, so as to
Yeah,
take away the obligation from the directors to prefer an insolvency petition at the right time, and but leave the ability open.
right. Already, I didn't think 66 was acting as too much of a stick, but you're absolutely right that it just suspending that would have been good enough.
Yeah. And I think the third thing that you said is very interesting uh, is well, the motivation seems to be that there aren't enough resolution professionals. Sorry, resolution applicants. Uh, do you think then that the time has now come to dilute Section 29A a bit? Um, I'm assuming that you're already aware of 29A, but just in case somebody is not, 29A talks about various measures that disqualify a person from becoming a resolution applicant, which includes various things like having been classified as a willful defaulter, uh, an incriminated, convicted criminal. But it also includes any person who's been in management control of a company who's been an NPA for more than 12 months. And of course, let me be clear here. I'm not making the case that convicted criminals or willful defaulters should be allowed into the fray. I'm only making the case that the original intent of 29A was to remove unscrupulous individuals. At least that's the word that was used from the group of potential resolution applicants. And I would have thought that somebody who has already been classified as a willful defaulter would have would have been sufficient, and there was never a need for a greater than 12-month NPA disqualification, because by very reason of the fact that that person is not a willful defaulter means that it was not because that person's fault that the company has been in NPA for more than 12 months. And so there's a clear case that there was no intention as such uh, to put the company into this situation. So why are these people disqualified? And perhaps do you think the time is right to at least water down this one provision, take this one provision out, which would in itself bring a lot of people into the fray?
That's a great point, and I think like a lot of things, bad regulation during this time of when we're responding to a pandemic. I think it's a good opportunity to do away with a lot of bad regulation, and you've suggested a great opportunity here to say that okay, two birds with one stone. Let's do it now temporarily to ensure that there are more plan applicants, and maybe it's a good thing to think about in the future as well. And I think there's great incentives for promoters if they think that they can be one of the applicants to put their heart into restructuring and trying to find a way out of it. So yeah, at least for the moment, a quick suspension of watering down, as you say, and then some more thought going into it when people realize that okay, this is working actually quite well. And yeah, as long as there hasn't been any willful misconduct, as you said, I don't see why we're preventing it going back to the promoters.
Yeah, I think I'd just like to add one more point there that just came to me. Another way of ensuring that people don't slip through the gaps, I mean, one could make the case that look, if a company has been NPA for more than 12 months and the directors haven't done anything, there is a serious risk that some misgivings have taken place. It's just that the banks haven't detected it. If that were the response to keep that one subsection in, or one disqualification clause in, I think that there would have been a counterweight that's just come to me that once the IP is appointed and has he or she has had a chance to investigate the affairs, um, there is section 66(1).
Hmm.
And if the IP has found some misgivings and brings any proceedings under 66(1), or I mean, of course, that threshold is very high. Even if brings proceedings for preferential transactions or undervalued transactions, automatically that also disqualifies that potential resolution applicant. Um, and so that's another way that the mischief can be arrested as such. And
Yeah,
that to my
absolutely.
mind,
And that brings, sorry, I
yeah,
interrupted you.
no, I was just saying that to my mind is another reason why that one disqualification can be suspended.
Yeah, I think it's a great way to put the. I've been identifying the theme in the New Zealand reforms as ensuring there's good faith at all steps, and this is such a good way to ensure that if through these various sections you haven't found any problematic conduct, then it's a why are they being prevented by putting up a plan? So yeah, I think great points. I agree.
Yeah. And I think, in fact, another reason that now comes to me is I'm sorry, this is snowballing. But another reason that comes to me is that if we've suspended sections 7, 9, and 10, um, does that mean that that person who's in control of the company, that director who's in control of the company, that has not been put into insolvency, who would then have become, I mean, 6 months or 1 year later, once Section 10A has run its course, that company would then have been NPA for more than 12 months.
Yeah.
That would then disqualify that person who otherwise would not have been disqualified.
And just the fact that you're identifying all these issues now, so many things are coming up without even putting that much thought into it. Just imagine how many issues lawyers can bring to courts and end up tying up the courts into this sort of litigation. So if the whole point was to free up the courts, then I don't think it's a solution at all. They should have actually created more NCLT benches rather than coming up with something so uh, badly drafted that is going to cause more litigation.
No, quite right. Quite right. There'll be a classic writ petition saying unequal treatment because the new defaulters have been exempted from Section 66(2), but we old defaulters have not.
Yeah, I think we have a question. Should we start looking at? I see a question in the chat box. Did you have more questions, Pulkit?
I was just going to actually conclude,
Okay.
and just say that I think that India has an opportunity at this point in time to come up with an elegant solution. We're not chest deep into the mud just as yet. I think maybe we are ankle deep, and so we've got a serious opportunity to come up with an elegant solution. And I think an elegant solution would perhaps be a fuller measure for perhaps something like a pre-insolvency process. And this could, this could be one of, we could take the examples of one of many pre-insolvency processes that have developed over the past few months. The Kiwi method, which you very succinctly explained at the beginning, is of course one option. The English method, the new English method of a soft touch administration, I think that has serious merits as well. And of course, the American Chapter 11 with the reduced administrative burden that has recently come out is another thing that one can consider. And I think another thing that's been left out that we were all apprehending would come around would be something to do with small and medium enterprises. And in fact, when the MSME Act was amended recently, increasing the threshold of a medium company from 10 crore capital to 100 crore capital, I thought that that was a precursor to something, to some insolvency resolution mechanism for MSMEs that was to come about. But unfortunately, we've been left hanging. So I think that that a fast track measure, a fuller measure for regular companies, and a fast track measure for MSMEs, I think whatever form that takes, I think that there can be an elegant solution there. And I would just like to say that the elemental features of such a solution would have to cover financial and operational creditors, whether secured or unsecured. And secondly, would have to provide for a cram down, either a scheme of arrangement type intra-class cram down or an IBC type cross-class cram down. Of course, I think here my preference would be a scheme of arrangement type intra-class cram down. And I think that's all that I sort of wanted to conclude by saying. I'd of course love to have your views before we go into the questions. If you could take 2 minutes and
Oh,
think
I
about
just would want any kind of options that we're considering now to be optional. So the more the merrier, right? All these options we're coming up with, looking at, we want to come up with. It's good as long as it's left for companies to choose, companies and creditors to choose which option to avail of. And I think you said something else about MSMEs, and I totally agree. We're really waiting for that fast track procedure, right? So we need something quicker for them. I'm starting to read the questions.
Yeah. I think there was a raised hand as well. I don't know which one do you want to go for first.
Oh, if somebody wants to speak, that's easier than having to read. So if anyone wants to ask your question, that'll be better.
Abhishek has asked a question in the chat. Abhishek, do you want to sort of unmute yourself and speak it out?
Hello, can you hear me?
Yeah.
Yes.
Yeah. Hi, Akshaya. Hi, Pratik. Thank you so much for your inputs, and it was a really nice conversation that that happened between you two, and it was really enlightening for us. And Pratik, thank you for those ideas. I think I'm a lawyer as well, and I'll be definitely using one of those ideas in for the advice that goes out now. Anyway, so my queries were actually pertaining to the suspension only. The first is basically the approach that has been that has been sort of implemented under Section 10A. Now, if you, I think this was discussed briefly. The RBI has put a moratorium on the repayment, and this will apply only to banks, financial institutions, and NBFCs. So they will start revising their repayment schedules as per that, and there will be a new repayment schedule which will exist now during the suspension period and even post the suspension period. But there is no moratorium for other set of creditors, say some bondholders, some foreign creditors for whom RBI is not the regulatory authority, and operational creditors, which is which are the main sort of threat for some of the companies. Now, and there will be a situation where the banks are not able to initiate any proceedings, but the operation creditors or some foreign creditor can initiate it. So the whole objective of the amendment of the ordinance to suspend the proceedings for a while may get thwarted, I think. So, could there have been a better approach for these? And I'm talking about post suspension period defaults only.
Yeah, I think we've both covered the fact that we're quite unhappy with the suspension. But could there have been a better approach? I would just say no, it shouldn't have been suspended in the first place. But I take your point that it's kind of such a piecemeal situation now. You have these banks having these sort of repayment schedules, no one else coming under any such thing. They can enforce their own. So it does sound like a free for all. So I think the solution is to allow the tried and tested insolvency resolution process to continue. What would you say, Pulkit?
Yeah. So I think we did discuss the point that that there isn't a rudimentary moratorium as such at present on any enforcement or recovery proceedings. And I think that the first thing would have to be to bring in something that stops people from terminating contracts, to bring in something that at least temporarily gives some room to breathe to the debtors, so that they can think about whether or not they can come in with a restructuring scheme. And so I think it can be the present regime perhaps needs to be supplemented by a pre-insolvency scheme. You know, like in England, they've been discussing for a while something called a restructuring moratorium, which is something that you would automatically get on a paper application without a hearing for 30 days. And that would be a moratorium that would apply to everybody. And that's actually a non-COVID measure. I mean, that's something that's being discussed, that's been discussed for at least the last couple of years in the UK. And they were very close to sort of bringing it in, and unfortunately just didn't get a chance. Um, so that would have been a pre-insolvency type process, quite similar to what New Zealand has brought in for COVID.
Okay, thanks, Pulkit. Thanks, Akshay. I think, can I just go to my second question, please?
Oh,
Uh,
sure. There's a
Yeah,
question.
sure. So, uh, basically what I'm saying is there is no suspension, like in the case of section 66 wrongful trading. There is no suspension for actions that are taken for preferential or undervalued transaction. But the problem lies here is the look back period. So once the insolvency commences, there may be some transactions falling during this suspended period, and there is a risk of the look back period getting over when the insolvency starts.
And also, since it says that these people will never be liable for these defaults, then look back period, even if it falls within the look back period, then you could argue that the way the ordinance is drafted, they'll never be liable because you have that blanket suspension of both 66 and the filing itself. But yeah, that suspension of 66, section 66 definitely needs to be corrected for all these reasons. I've seen some other hands.
Yeah, I don't know how to look at who got their hands raised. Urvashi, I don't. Can you?
Anand has raised the hand. Anand, do you want to ask anything? Mr.
Thanks,
VV
thanks,
Anand.
Pulkit. Thanks, Akshay.
Oh,
Yeah, thank you so much, Abhishek. Mr. Vivian. So by the time he joins, I'll ask my question. So Akshaya and Pulkit, thank you so much. Akshaya, in one of your paper I was reading, you have argued for a modified Revlon duty for directors in the pre-insolvency regime, like when the company is in zone of insolvency or twilight period, what we call. So if you could elaborate on it a bit, and also I don't know, but while reading the paper, it seemed that you favored debtor in control more than debtor in possession. So what's your take on it? And again, Pulkit, what's your take? Which is the better model?
thanks, Urushi. I don't know why that paper seemed to suggest that. I don't favor the creditor in control model at all, but unless there is some sort of misconduct that requires the management to be to be taken out of control. But just to kind of briefly summarize what I was suggesting in that paper, and I think I may have touched on that when I discussed the Jet Airways case. I just found that the incentive structures in India are such that for the big banks, they may not actually, in certain cases, high-profile cases, they may not take the company into the insolvency resolution process at all, despite knowing that this company has not paid its debts for a long time. Employees, and in Jet Airways, employees weren't being paid. It had become public information that this company is having huge solvency issues, but nobody's dragging that company into the insolvency resolution process. And that may be for the good if that's resulting in a good pre-insolvency kind of restructuring. But what we saw in the news, and I don't have more examples of smaller companies because you get these things in the news only with big companies, right? But for Jet Airways, what we saw in the news was that there were offers made by Etihad and someone else, but the one of the terms of those offers were to ask the promoter to step down and from his position, and that is what may have suggested that I'm favoring a creditor in control model to you, because I'm saying that just because the promoter wants to retain their place in the company, they're giving up those deals, which kind of was proving counterproductive. No one's taking that company to court, and then there are no efficient pre-insolvency incentives in place. So I suggested a kind of modified Revlon duty, which in the US applies in takeover situations when the company is already on sale, then the directors are under a duty to sell to the highest bidder. And in this context, in an pre-insolvency context, when you know that this company has solvency issues and is looking for bidders, then we should just have a kind of rule that says that director should sell to the highest bidder irrespective of the terms, simply because we don't want bids to go fall through just because the promoter wants to retain their position in the company. That's what I was saying in that paper, but I do favor the debtor in possession model.
Right. Actually, I'm so sorry for that. I meant that only, that you seem to favor debtor in possession more than creditor in control. However, in India, we have clearly moved from debtor in possession to creditor in control. So, like, what's your take on it? Why do you favor one model over the other? And I want Pulkit also to answer the question, that which is a better model, do you think?
Okay, I'll be very quick and give the floor to Pulkit then. We had that in the Sikh Industrial Companies Act, which didn't go very well. Nobody wants to hear of the Sika right now. But I think we've kind of thrown the baby out with the bathwater, right? Because there were a lot of problems there with how courts were functioning. Courts were trying to retain, keep employees in their jobs. And so the many times cases were, even once they say this is not viable, it would go to the High Court, and the High Court would say, okay, continue proceeding. So that's why it didn't work out so well. It wasn't that the debtor in possession model itself was the reason for the failure of Sika. So that's my take, but I'll leave it to Pulkit now.
Yeah, thanks, Akshaya. This is always a hot topic. It has been a hot topic, and it will remain a hot topic. And I think that this is reminiscent of what I started by saying when I started by saying that it's very difficult to have 2020 vision right now and to say what the ideal features will be. We can only guess. It's an economic experiment, and we've just got to keep adjusting ourselves as we go along. Now, there is absolutely no reason why two schemes, one with a debtor in possession model and one with a creditor in possession model, cannot coexist. I think both have their merits, and there is a time when one is more relevant than the other. So to say that, so Akshaya is quite right. We threw the baby out with the bathwater when we said, all right, BIFR goes out, and so does debtor in possession. I think at that time it seemed like the reasonable thing to do. I mean, I'm barely aware that in India, if somebody says, "Oh, debtor in possession model, let's bring that back in," everybody's going to come at you with sticks and batons and whatnot, bullets, perhaps. So I think we've got to be mindful of the benefits that a debtor in possession model brings with itself. And I think the 9 June circular by the RBI is nothing but a debtor in possession model, isn't it? I mean, it leaves the debtor in possession, gives the creditors 30 days, gives the debtor 30 days of breathing space to convince their creditors that, look, I can do something about it, and then another 180 days of moratorium to actually implement what you want to do about it. But of course, the limitation there is that it's only limited to scheduled lenders, and I think it really does make sense to have a parallel procedure, a pre-insolvency type procedure where debtors remain in possession, because I think there is merit in giving them a chance to recover from a bad situation before you throw them out and say, let somebody else come in.
All right. Thank you so much, both of you. Any further questions? I don't think we have any further questions. So if you would like to make your concluding remarks.
Okay,
so I took my opportunity before we took the questions. So I think, Akshaya,
okay. Yeah, concluding remarks, mostly that I'm very glad to have heard a lot of the points that came from this discussion, right? Pulkit's points, the questions others have raised. And overall, I think I'm glad to see that there seems to be a consensus that the ordinance has not worked out very well, was not a good idea. Something needs to be done about it. So hopefully we're all going to put our 2 cents into it in various ways in the government's listening, and we'll get, prior to going to Parliament, we'll get some sort of more guidance in terms of pre-insolvency proceedings, as Pulkit has been saying. Hopefully that at least would help right now. And in Pulkit's concluding remarks, I think you had said something about, oh, it's just we're ankle deep, not chest deep, or something, and I felt so good to hear that optimistic note. So hopefully that's the right note to leave it on.
Over to you, Pulkit, your concluding remarks.
I that's what I said. I did mine just before the questions. Those were my concluding remarks, actually. That's why I let you.
Thank you so much, Pulkit and Akshaya. It was a very insightful session. All of us enjoyed a lot and learned a lot of things from the session itself. Also, I would like to thank all the audience members for such an overwhelming response we have received for this particular talk. So, hope to see you back again sometime for GIP sessions, for the web talks. Thank you so much.
Thanks, Urvashi. Thanks, everyone.
Yeah, thank you very much. Thoroughly enjoyed it.